you're going through a divorce, you've probably heard the term mediation come up, whether from your attorney, a friend, or from the court itself. Mediation is a process where a neutral third party called a mediator helps you and your spouse try to reach agreements on issues like parent time, child support, alimony, and property division, instead of having a judge decide those issues for you. I'm Ryan Gregerson with RCG Law Group, and here's how mediation works in Utah. A mediator's job isn't to take sides or decide who's right. The mediator is a neutral facilitator. They don't represent either spouse, and they can't force either of you to settle. Instead, their role is to facilitate productive negotiations, help both sides better understand the strengths and weaknesses of their positions, identify practical solutions, and guide the discussion towards possible compromises. Many mediators are attorneys or retired judges, but during mediation, they are not acting as your lawyer. One of the biggest concerns people have is whether they'll have to sit in the same room as their spouse all day. The good news is that in Utah, that's usually not how mediation works. When both parties have attorneys, mediation is almost always conducted in a caucus format. That means each side stays in a separate room while the mediator moves back and forth between them to discuss the issues, communicate settlement offers, and help narrow disagreements. Even if you're attending mediation without attorneys, you can usually request a caucus format if being in the same room would make productive negotiations difficult. A mediation session typically begins with the mediator explaining the process and discussing the issues that still need to be resolved. Those often include parent time, child support, alimony, property division, and debt allocation. From there, the mediator works with both sides to see whether agreements can be reached. In Utah divorce cases, mediation is required before the case could proceed to trial. The exact requirements depend on the type of case and the issues involved, and there are exceptions, including potentially cases where certain domestic violence or other circumstances may make mediation inappropriate. It's also important to understand that mediation doesn't have to resolve every issue to be successful. Many cases settle completely, while others resolve only some of the disputed issues. Any agreements that are reached are typically put into a written settlement agreement. If approved by the court, those agreements become part of your final divorce decree. Resolving even a few issues through mediation can reduce the time, expense, and uncertainty of going to trial. Your attorney and the mediator serve two very different roles. The mediator must remain neutral and cannot tell you what's in your best interest or give you legal advice. Your attorney's job is to protect your interests, explain your legal options, evaluate settlement proposals, and make sure any agreement is one you fully understand before you sign it. Many people attend mediation with their attorney present, while others consult with the attorney before or after mediation. The right approach depends on the circumstances of your case. The length of mediation varies. Some cases resolve during a single half-day session. Others require a full day or multiple sessions, especially if there are complex financial issues or a high level of conflict. So to recap, mediation is a structured process where a neutral mediator helps you and your spouse try to reach your own agreements instead of having a judge make those decisions for you. And despite what many people expect, most Utah mediations are conducted with the parties in separate rooms, making the process much less intimidating than many people realize. If you're preparing for mediation and want to understand your rights, your options, and how to put yourself in the best position for a successful outcome, RCG Law Group is here to help. Schedule a consultation today.